All rise.
Judgment in the appeals in Re Sigma Finance Corporation and in Re the Insolvency Act.
Lord Mance will give the judgment.
Sigma is a structured investment vehicle which defaulted in the recent financial crisis with assets far short of its liabilities. The security trustee governing its relationship with creditors provided for a 60-day period after an event of default within which the trustee holding its assets was to realise them and create pools of assets to meet Sigma's short and long-term liabilities. Clause 7.6 also provided that the trustee should, so far as possible, discharge on the due dates any short-term liabilities falling due for payment during such period. The Court of Appeal held that Clause 7.6 gave creditors whose debts fell due during the 60-day period priority in the order in which they fell due over all other short and long-term creditors whose debts fell due after that period. The Supreme Court, by a majority of 4-1, has now allowed the appeal of the other creditors. It has held that upon the true construction of the deed and viewing the scheme as a whole, Clause 7.6 was not intended to give one fortuitously defined group of creditors priority over another in insolvency. Lord Walker dissented.
Judgment in the appeal of the Queen on the application of L against the Commissioner of Police of the Metropolis.
I will give the judgment in this case. The appellant obtained a job as a playground assistant. In connection with her employment, the police were required to provide her with an enhanced criminal records certificate. They disclosed to the school that she had been accused of neglecting her child and non-cooperation with social services, and her employment was terminated. She claimed that the police disclosure violated her right to respect for her private life under the Human Rights Act. The Supreme Court holds that when determining whether to disclose non-criminal related information retained in police records in connection with an application to work with vulnerable persons, the police must give due weight to the applicant's right to respect for her private life. However, the facts narrated were true, the allegation was directly relevant to her employment, and the school was entitled to be apprised of the information. Therefore, while the consequences for the appellant's private life are regrettable, disclosure could not, in this case, be said to be disproportionate to the public interest in protecting vulnerable people. The appeal must be dismissed. The court will now adjourn.